Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
People v. Locksley Williams. Decided on November 25, 2025. Canataro, J. In order to declare readiness for trial upon a local criminal court accusatory instrument, CPL 30.35a requires the people to certify that all counts in the accusatory instrument meet the statutory requirements of facial sufficiency and that any non-compliant counts have been dismissed, thereby tying trial readiness to the filing of the required certification. The statute is silent, however, as to what, if any, remedy is available when the people provide the required certification, but the representations made as to at least one count of the instrument are inaccurate or incorrect. We hold that under such circumstances, the statute does not require invalidation of the people's statement of readiness. Instead, dismissal of the defective count is the appropriate remedy. 1. Following an incident in which defendant struck a pedestrian with his vehicle in a Brooklyn intersection, defendant was charged by misdemeanor complaint with one count each of aggravated unlicensed operation of a motor vehicle in the second degree, Vehicle and Traffic Law 511-2AIV, aggravated unlicensed operation of a motor vehicle in the third degree, unlicensed operation of a motor vehicle, and failure to obey a traffic control signal. The misdemeanor complaint contained numerous factual allegations in support of the unlicensed operation counts, but none supporting the failure to obey a traffic control signal count. The people later filed an information which, once again, did not include factual allegations concerning the failure to obey a traffic signal count. The people also filed a statement of readiness and certification pursuant to CPL 30.35a, stating that all counts in the accusatory instrument met the requirements of CPL 100.15 and 100.40, and that any counts not meeting those requirements had been dismissed. It is undisputed that the count for failure to obey a traffic signal was facially insufficient, and therefore did not comply with the requirements of CPL 100.40. Several months later, after the people's CPL 30.30 time had expired, defendant moved to dismiss the information for facial insufficiency and on statutory speedy trial grounds. Defendant contended that the inaccuracies in the people's CPL 30.35a certification, specifically those concerning the count for failure to obey a traffic control signal, rendered the statement of readiness invalid. In response, the people conceded that the count charging failure to obey a traffic control signal was facially insufficient and therefore should be dismissed. Criminal court dismissed that count, but otherwise denied the motion, determining that the people met CPL 30.35a's requirement of filing a certification, and that inaccuracies contained within the certification, with respect to the dismissed count, did not warrant dismissal of the entire instrument. The appellate term affirmed, holding that the statute requires only that a certification be made in order for a statement of readiness to be valid, and does not provide for sanctions in the event that the certification is ultimately deemed to contain inaccuracies. A judge of this court granted defendant leave to appeal, and we now affirm. 2. Defendant argues that CPL 30.35a requires the people to accurately attest to the facial sufficiency of the counts contained in an accusatory instrument, but that assertion finds no support in either the plain language of the statute or its legislative history. It is fundamental that a court, in interpreting a statute, should attempt to effectuate the intent of the legislature. As the clearest indicator of legislative intent is the statutory text, the starting point in any case of interpretation must always be the language itself, giving effect to the plain meaning thereof. Majeski v. Broadalbin Perth Central School District. CPL 30.35a provides, upon a local criminal court accusatory instrument, a statement of readiness shall not be valid unless the prosecuting attorney certifies that all counts charged in the accusatory instrument meet the requirements of sections 100.15 and 100.40 of this chapter, and those counts not meeting the requirements of sections 100.15 and 100.40 of this chapter have been dismissed. As relevant here, CPL 100.40 requires that a misdemeanor information, unlike a complaint, contain non-hearsay allegations establishing every element of the offense charged and the defendant's commission thereof. CPL 100.401c, see also CPL 170.65(1), requiring that a misdemeanor complaint be replaced by an information for purposes of prosecution. On its face, the clear language of CPL 30.35a requires that the people, in conjunction with filing their statement of readiness, certify that each count of the accusatory instrument is supported by facially sufficient, non-hearsay allegations, and that any counts that are not so supported have been dismissed. However, the statute does not provide for any readiness-related consequence for a mistaken or incorrect certification. See Russell v. New York University. Statutory interpretation is not an invitation to rewrite the law by discovering some meaning not intended by the drafters or ignoring words and their clear and obvious import. Such a requirement would make little sense because facial sufficiency is a legal question, sometimes a close legal question, and the people cannot reasonably be expected to attest accurately to the outcome of a defendant's challenge to the facial sufficiency of the instrument. See e.g. People v. Arroyo. In determining that one count of accusatory instrument was facially insufficient, the court reviewed numerous, often conflicting cases and conducted a careful analysis of the allegations. Defendant contends that the people's obligation to certify facial sufficiency should be treated the same as the requirement that they certify compliance with their discovery obligations under CPL Article 245. A comparison of the text of the relevant provisions reveals why this interpretation is incorrect. CPL 30.35, as originally enacted in 2019, specifically stated that any statement of trial readiness must be accompanied or preceded by a certification of good faith compliance with the disclosure requirements of CPL 245.20, and the defense shall be afforded an opportunity to be heard on the record as to whether the disclosure requirements have been met. Mirroring this provision, CPL 245.53 provided that the prosecution shall not be deemed ready for trial for purposes of CPL 30.30 until it has filed a proper certificate of compliance. Former CPL 245.53. Based on this language, we explained in People v. Bay that, read together, CPL 245.50 and CPL 30.30 require that due diligence must be conducted prior to filing a certificate of compliance. Thus, unlike the Subdivision 5A certification requirement, the legislature specifically provided that an invalid certificate of compliance would render the people's accompanying statement of readiness illusory. The legislature could have, but did not, similarly tie the accuracy of certification pursuant to Subdivision 5A to the people's trial readiness. It is this legislative choice that the dissent ignores when it insists without citation that the problem that the Speedy Trial Framework and CPL 30.35a address is prosecutorial delay. Dissenting Op. at 9, conflating CPL 30.35a with the preceding subdivision and disregarding significant differences between the two. Although there is limited legislative history regarding the presently enacted statute, earlier in 2019, a bill was introduced in the Senate that proposed a version of CPL 30.35a that would have imposed consequences for an inaccurate subdivision 5A certification similar to those imposed for discovery violations discussed above. See 2019 NY Senate Bill S-1738. Specifically, that bill proposed a subdivision 5A that would have provided, upon a local criminal court accusatory instrument, a statement of readiness shall not be valid unless all counts charged in the accusatory instrument meet the requirements of CPL 100.40, 1, 2, or 3, and the prosecution moves to dismiss any counts not meeting such. Explaining the operative intent behind the earlier version, the sponsor's memo stated that it would provide that a statement of readiness shall not be valid unless the prosecuting attorney certifies that all counts are converted and facially sufficient, and that those counts that are not have been dismissed. However, the language employed in the earlier bill went much further in its application, essentially requiring dismissal of a statement of readiness whenever the accusatory instrument did not actually comply with CPL 100.40. The version ultimately enacted into law more closely tracks the sponsor's stated intent. Indeed, it uses the sponsor's memo language verbatim to require only that the people certify that all counts charged in the accusatory instrument are facially sufficient. This provides some evidence that the legislature considered and rejected language tying the people's readiness to the actual facial sufficiency of the accusatory instrument in favor of a requirement that they certify its sufficiency. See Kimmel v. State, concluding that earlier bills may shed light on the critical differences in the version that was ultimately enacted. Defendant further argues that if an inaccurate CPL 30.305a certification does not lead to the invalidation of the statement of readiness and subsequent dismissal of the entire accusatory instrument, then that provision would be rendered functionally meaningless. We disagree. As noted in the practice commentaries, Subdivision 5A functions to end the historical practice by the people of removing hearsay allegations and declaring trial readiness on some counts in an accusatory instrument, but not others. See William C. Donino, CPL 3030. As interpreted by some courts, this practice served to unfairly limit the effect of the Speedy Trial Statute by allowing the people to stop the clock on some counts while keeping the case firmly in a pretrial posture with respect to other counts. See e.g. People v. Minor. By tying readiness to a certification that all counts are facially sufficient and properly converted, CPL 30.305a makes trial readiness a singular event for the entire accusatory instrument. Under this rule, the people are required to make a choice. Either indicate their readiness to proceed to trial on all remaining counts, subjecting the entire accusatory instrument to the stricter facial requirements for a misdemeanor information, see CPL 100.404, or elect not to declare trial readiness on any count. This rule effectively serves to streamline pretrial motion practice, opening a window during which a defendant can move to dismiss any count which does not meet the facial sufficiency requirements for a misdemeanor information. See CPL 170.10, 170.30, and thereby ending partial conversions by piecemeal approach. In contrast, the remedy sought by defendant here, dismissal of the entire instrument, would serve no beneficial purpose. Finally, that the legislature intended Subdivision 5A to only require certification, not necessarily an accurate certification, is not absurd as defendant suggests. As we have explained, the CPL already imposes the consequence of dismissal for proceeding to trial with a facially insufficient count. Facial sufficiency is frequently subject to reasonable disagreement and serious legal debate. See e.g. People v. Farrell, People v. Willis, People v. Hill. Given that legal sufficiency is not always clear-cut, it is reasonable to conclude that the legislature did not want to require the severe sanction of dismissal of the entire accusatory instrument as a consequence of the insufficiency of a single count. Though nothing in CPL 30.30 5-A mandates the invalidation of the People's Readiness Statement based on an inaccurate certification, we expect prosecutors will carry out this statutory command with the diligence and care attendant to their positions, and examine the underlying accusatory instrument for compliance with CPL 100.15 and 100.40 before making the required certification. Accordingly, the order of the appellate term should be affirmed. Order affirmed. Opinion by Judge Canataro. Judges Garcia, Singas, Troutman, and Holligan concur. Judge Rivera dissents in an opinion in which Chief Judge Wilson concurs. Decided November 25, 2025.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.